I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I ruled, then that's not my...
Hey everyone, welcome back to today's video. We're stepping once again into Judge Perkins' courtroom, a place where patience wears thin and reality hits fast. Today's case features another self-declared sovereign citizen who truly believes he understands the law better than licensed attorneys and sitting judges. Armed with internet myths and unearned confidence, he walks in expecting to outplay the system, only to slam straight into how the law actually works. What follows is a familiar yet still shocking collapse of fantasy under real courtroom authority. Buckle up, because this goes exactly where you expect, and then some.
Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis. Please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter a not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
As it turns out, this so-called legal genius can recite imaginary laws for hours but can't manage something as basic as sending a proper email. That alone says everything. He speaks with absolute certainty, claims the system is corrupt, and insists he knows better, all while failing at the simplest real-world tasks. It's the perfect snapshot of the sovereign citizen mindset: big words, bold claims, and zero understanding of how anything actually functions. In a courtroom ruled by procedure, that kind of confidence doesn't make you clever, it exposes how unprepared you really are.
Resending at the moment.
I'm going to put my email address in the chat, and I'll put my email so you'll have it, and send that to me. And I'll have an opportunity to read that. I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that, I will.
After multiple failed attempts, and what feels like sheer luck, he finally manages to send his email to Judge Perkins. Victory? Not even close. The judge needs only a few seconds to see straight through it and dismisses the message outright. No debate. No analysis. Just instant rejection. That's when reality hits hard. The confidence disappears, frustration takes over, and the man who claimed he could outsmart the legal system crumbles the moment someone with real legal knowledge shuts him down.
Go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I'm not give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venue.
Here's the reality check he never saw coming. This wasn't some fictional Article 1 judge like he kept insisting. This was a real sitting judge, and that difference matters. The justice system doesn't hand out venue changes just because you don't like the outcome. You don't get to hop courts, shop jurisdictions, or move your case because things aren't going your way. That's not strategy, that's entitlement colliding with how the law actually works, especially in Judge Perkins' courtroom.
Okay, I'm denying the motion to dismiss, okay? I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay. I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, that's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming.
If the situation were truly unlawful or overwhelming, the case would have been dismissed. Simple. But that didn't happen. The motion was denied because it recycled the same worn-out sovereign citizen arguments courts have rejected countless times before. A real judge doesn't need hours to recognize that. In Judge Perkins' courtroom, one glance is enough to see there's no legal basis, no authority, and no valid argument, just recycled rhetoric pretending to be law. And that's never enough to move a case forward.
Like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to
Judge Perkins has dealt with countless defendants just like this, and not a single one has ever presented a valid legal argument. Every buzzword, every theory, every claim has already been heard and rejected. Unless this guy somehow uncovered a mythical sovereign citizen handbook no one else has seen, which we both know didn't happen, nothing new is coming today. All that remains is recycled nonsense, misplaced confidence, and the inevitable result, a self-inflicted courtroom collapse that shows exactly how not to argue the law.
To give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenant right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it. This due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue at that.
At the jury of peers, he says. That's generous. What he's really asking for sounds more like a room full of people with a third-grade understanding of the legal system. Good luck persuading anyone with reason or evidence when your argument relies on fantasy instead of facts. Courts don't lower their standards to meet your comprehension. You're expected to rise to theirs. And when you can't, the request doesn't look bold, it looks desperate and completely detached from reality.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2, moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages / losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court.
This is where the sovereign citizen argument fully collapses. Article 1 judges are federal judges whose authority comes from Article 1 of the U.S. Constitution. Judge Perkins isn't one of them. He's a state judge whose authority comes from the Michigan State Constitution, empowered through the 10th Amendment. That's basic constitutional law. Mixing the two doesn't create a loophole, it exposes a fundamental misunderstanding of jurisdiction. And courts have zero patience for that confusion. 9. Let's be clear, he couldn't even get the judge's title right. And still, Judge Perkins delivers one final, perfectly timed remark before closing the matter and walking away like it's just another day at work. And that brings us to the end of today's video. I'm officially back from my trip and ready to get back to it. Huge thanks to everyone who kept watching while I was away.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion, all right? And you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming
The 36th
down.
district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. There's a distinct.
Yeah, I was told to call the clerk the day that I was locked out. The moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say. July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that day. So you trying to play with me? You could dismiss it today, sir. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you want all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of July 22nd. The final date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
7. At the jury of peers, he says. That's generous. What he's really asking for sounds more like a room full of people with a third-grade understanding of the legal system. Good luck persuading anyone with reason or evidence when your argument relies on fantasy instead of facts. Courts don't lower their standards to meet your comprehension. You're expected to rise to theirs. And when you can't, the request doesn't look bold, it looks desperate and completely detached from reality. 8. This is where the sovereign citizen argument fully collapses. Article 1 judges are federal judges whose authority comes from Article 1 of the U.S. Constitution. Judge Perkins isn't one of them. He's a state judge whose authority comes from the Michigan State Constitution, empowered through the 10th Amendment. That's basic constitutional law. Mixing the two doesn't create a loophole, it exposes a fundamental misunderstanding of jurisdiction. And courts have zero patience for that confusion. 9. Let's be clear, he couldn't even get the judge's title right. And still, Judge Perkins delivers one final, perfectly timed remark before closing the matter and walking away like it's just another day at work. And that brings us to the end of today's video. I'm officially back from my trip and ready to get back to it. Huge thanks to everyone who kept watching while I was away.
Today is the date and time set for an arraignment. Go ahead, Counselor.
For purposes of arraignment, my client stands mute.
Enter not guilty plea on his behalf, give him a $0 bond. It appears that we're having trouble running driver's license, period, with the system seems to be down apparently. Mr. Lopez off the record indicated that he had a valid driver's license. He also has a careless driving. I have an allegation that reads on the record that Mr. Lopez apparently is driving and operating I don't know if this is a crotch rocket or not. But it
super
like,
bike.
Hold on a second, sir. So if you interrupt like that and you say, I always say this, if you don't talk, you just might walk.
Okay.
That's the line for the day.
The arraignment starts routinely, but tension rises fast. As the judge explains the charges and warns against interruptions, the defendant ignores counsel and jumps in. The judge responds sharply, reminding him that unnecessary talking can cost him his freedom. In moments, a routine hearing turns into a lesson on courtroom discipline and how quickly things can spiral out of control. 11.
Read these things so that your counsel will be apprised of what the allegations suggest. So when people interject, like you just did, and said, I believe, superbike, then that just checks off one of the things that the prosecutor doesn't have to prove anymore. You understand where I'm coming from, Mr.
Yes,
Lopez?
I hear you. Yes, I hear you,
All
Your
right.
Honor. I'm sorry.
That's all right. That's all right. So it says here, Ms. Harris, that Mr. Lopez was riding this superbike. Is that what you said, superbike?
It's a motorcycle. It's just a motorcycle.
What is a superbike?
I just I don't like the stereotypical name that it got the first time, so just a motorcycle.
Wait a minute. So you have a problem with them calling it a crotch rocket?
Yeah.
But you're caught up in semantics, huh?
Yeah, it's just a motorcycle. It's just a motorcycle.
Well, you got different kind of motorcycles. Is it a dirt bike, one of those 250 dirt bikes, or is it one of those 1,000 racing bikes? What is it?
Yeah, it's one of those.
So is it
Your Honor,
crotch
can
rocket?
we not have him answer all of these questions?
Hey, he already mentioned it. I didn't. He already said it. I'm trying to. Okay, anyway, I'll go digress on that. On this, Harris. Traveling at greater speed limit, southbound Waterman, disregarding stop sign. So that's where the careless driving comes in. I'm thinking what the officer is meaning by careless driving, which is a 3-point offense as it stands.
Yes.
You knew that?
I didn't know that.
So, this is like one of those, maybe he needs to take the better driver's course. Let's see if you have a driver's license in hand, sir. Do you have a copy of your driver's license with you? Congratulations, Miss Harris. Join the
And he
breakout
has a
room.
cycle endorsement also.
Yeah,
Yeah.
cycle endorsement.
Now, I don't know if it's valid, but it does read that.
Yeah, it's valid.
Yeah, that's what you say.
No.
Yeah.
From there, the situation escalates. What should have been a simple clarification turns into an argument over wording, labels, and semantics. Each interruption weakens the defendant's position as the judge patiently explains how careless driving is legally defined. Despite repeated warnings, the defendant keeps talking, slowly dismantling his own case in real time. 12. Then the consequences land. The defendant insists he was wrongly cited, yet still wants to hear the court's offer, a contradiction the judge immediately calls out. The judge explains why half admissions and post-plea regret aren't tolerated, citing how often defendants try to undo their own decisions. With patience gone, the judge sets a trial date, triggering visible frustration. Like the video, subscribe to the channel, and we'll see you in the next one.
I don't know if it's valid. Hold up. Hold
Your
on.
Honor, I'm very careful when
he likes to talk. Go ahead.
I feel like I was wrongfully convicted for that. I'm very careful when I'm driving. It's just I don't know, the officer just
All right.
I know what it looks
So,
like.
We need to set a trial date.
No, I don't need a trial.
Join the breakout room. Speak with the lawyer. You talk too much, sir.
Okay.
All right. Ms. Harris, are you ready on anyone?
Is there an offer on Mr. Lopez?
Well, I have to verify his license, and he indicated. So let's go back on the record with Mr. Lopez. He indicated to the court that the officer essentially he didn't, what I understood, he didn't do what the allegations suggest. So that leads me to having to set a trial date. Yeah, I can allow you to respond to that.
Do I think a trial would be in the best interest? Yes. However, my client wants to know what the current offer would be.
Yes.
Well, again, Mr. Lopez, you want the offer, but in the same breath, you say that the officer wrongly wrote you the ticket. So how are we going to make a factual basis, an active factual basis for this type of charge when you're not prepared to admit to it?
I'm prepared to admit to it.
I'm not going to do it. I'm going to set a trial. No, because you're not going to come back in here, and I already have enough of these. What is this here? Request to withdraw admission. I have enough of these. One is sitting here on my desk right now.
Then the consequences land. The defendant insists he was wrongly cited, yet still wants to hear the court's offer, a contradiction the judge immediately calls out. The judge explains why half admissions and post-plea regret aren't tolerated, citing how often defendants try to undo their own decisions. With patience gone, the judge sets a trial date, triggering visible frustration. Like the video, subscribe to the channel, and we'll see you in the next one.
What I call buyer's remorse. After you go plead guilty, then you get the points on your license, and then they mess with your chauffeur's license. Now you want to come back to the court and say, something, I didn't know my rights, or I want to do this, is affecting me in this negative way. So I'm not going to do it. I'm going to set a trial date. That's another thing. When you talk like you do, and you keep on talking, then that's what happens. Trial date is going to be January 24th, 2024.
Jesus Christ. Jesus Christ. Oh my God.
All right, keep on interrupting me. Probably it's gonna be January 24th, 2024 at 9 a.m., sir. Have a very good day. Best of luck to you.